slides on this. The slides that I'm using this afternoon are designed by my colleague, Dr. Mutuma, who's really the guru on alternative dispute resolution, not just in international matters, but on domestic matters as well. So I am paying homage to him, and I do indicate that the slides are his own, is from his intellect, really, so to speak. So the topic is peaceful settlement of disputes in international law, and we've already mentioned the foundation or the context in which we are discussing this. And without belaboring, is that we all know that disputes are really disagreements. But within the international law, there are two, what we could categorize them into two. They could be disagreements on a point of law or fact. It could also be another categorization, a conflict of legal views or interest between the parties. And as we go along, we will see that some matters are purely political matters, other matters are purely legal matters. But the point that we want a couple of definitions on what international disputes are. And the first by natura is that it's an actual disagreement between states regarding the conduct taken by one of them for protection or vindication of the interests of the other. So natura is really focusing here on why conduct is taken, saying it could be for protection or vindication of their interests. But I think the point that I would want to emphasize is that it really refers to that agreement, actual disagreement between states. And this could be on the basis of a couple of or different reasons, so to speak. Brownlee, and I'm sure you have seen his text in the library for those who have checked, he says that it is a disagreement on a point of law or fact, a conflict of legal views or of interests between two states. Disputes relate to an alleged breach of one or more legal duties. They may also relate to a question of attribution of title to territory, to maritime zones, to movables, or to parts of the cultural heritage of a state. So Brownlee here expounds a little bit and says some of the reasons why states would have disputes would be because of course, on a point of law or fact, but giving examples, issues of territory, when we were talking about a state having mandate over a territory. So the question of territory is fundamental, and you may have states disagreeing to issues of territory, and we can give examples as on this. So again, as we have said, we look at the categorization. I've already mentioned that you may have political disputes and you may have legal disputes. And what we are really concerned about mainly would be legal disputes. But having said that, it's important for us to also note that there are political disputes, and political disputes what we would say are non-justiciable. They are not matters that you would go to the ICJ, for instance, and talk about. They are political in nature, and therefore they are matters that would really require the states to find a way out. And these are real. In many instances, you will hear states making a political stand on a particular matter. But what is of real focus for us is the legal disputes, which not only include questions of law, but also the law itself. Having said that, allow me to say that when we are looking at the Pacific means of settling disputes, it also will require that even where there are political disputes, that they do apply this means when settling their political disputes, because political disputes have the potential of ending up in catastrophes, in wars, etc. So in as much as we say that they are non-justiciable, you may not take them to court, but it is important that they are also settled. And this Pacific means are an important avenue of settling political disputes as well. So the origins, or really the genesis of this specific means of solving disputes, we would say it's really the first Hague Peace Conference in 1899, in which states really agreed that it is important to ensure that you have a peaceful means of settling disputes for the reasons that we have already spoken to. And this philosophy found its way in the UN Charter. You remember when we were looking at and you do have copies of the UN Charter, and one of the fundamental principles that is set out in the UN Charter is that states must never use force in solving disputes. The UN Charter clearly and expressly prohibits the use of force to solve disputes. Articles 2 and 3, 2 and 4, and 33, as we will see, really give guidance to states to only use peaceful means to settle disputes. What I would like to call on you to do is, after the class, to download the principles of international law concerning friendly relations and cooperation among states. And what this legal instrument, which is a UN General Assembly resolution, did is to talk about what are the key principles that should really be taken into account with relation to how states relate with each other. So what this resolution does is really just to emphasize, or really to augment the principle that there ought to be a peaceful settlement as well. So it's important that you look at it, but we will also touch on it as we go along. The ICJ is also empowered to ensure that international disputes are peacefully resolved. Remember, even in a domestic setting where there is no access to a formal mechanism, means that people take issues in their own hands. So in the same way, in the international scene, the ICJ is a formal framework within which states can seek recourse. And the idea, again, is that where this out-of-court agreements have failed, then states can find recourse at the ICJ. Article 52 of the Charter also recognizes the rights of members to establish regional arrangements or agencies. And we will see that, for instance, in the African context, we have the African Court of Justice, and we will see that under the European context, they do have their own framework, etc. So that is recognized as also a mechanism to ensure that there is peaceful settlement of disputes. Article 1.1 of the United Nations Charter really gives us insight into the whole idea of settling disputes peacefully. It sets out as a major objective of the UN as being to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. In fact, every time we have a class, I don't think there is any class that we don't talk about the need for, or rather talk about peace and the objectives of the United Nations being really to ensure that there's no breach of the peace. It always comes up because it's a very foundation upon which the United Nations was formed. Article 2.3, peaceful settlement of disputes is a cardinal principle of international law, and the principle is set out in Article 2.3 of the Charter, which provides that all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. And note the word here is shall. So it outlaws any other means except peaceful means to ensure that international peace and security are not endangered. When you look at Article 33, it provides that the parties to any disputes, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. Now, we see a couple of things here. The first being the principle is set out in the objectives of the UN Charter, but also in Article 2.3 and 2.4, that the idea or the foundation upon which the United Nations is formed is that the objective is to maintain peace, and the idea is to ensure that there is no breach of international peace and security. But what Article 33 does is then to go ahead and give states the modes or the modalities that they could use in settling disputes. So if you say that they shall use peaceful means, what are some of these means that the states can use? And we will look at this in turn. These means or these methods can be categorized into two. Number one is diplomatic means, because this means it's the states that are actually taking active part in looking for solutions jointly. The diplomatic means, which in this case would encompass negotiation, mediation, inquiry, and conciliation. But there's also the adjudicative means, which is now resorting to an adjudicative body to make a decision or to guide on the way forward. So in this case, we talk about arbitration and judicial settlement. And in this case, in the international plane, then you are talking about the ICJ. So we start off with negotiation. And of course, there is nothing complex about negotiation. It's just as we know it in the domestic realm, it's the same principle in the international realm as well. And this is as stated here, the oldest and the most common and simplest methods of settling international disputes. And I'd like to pause there for a minute and say, why do you think negotiation is what would be said to be the most common? What do you think is attractive about negotiation? And of course, by negotiation, I started off by assuming that we will understand negotiation is just as in the normal course of day-to-day living, where you have parties where they engage in direct discussions, and in this case, using diplomatic representatives, and they look at the issues and discuss the issues and seek a way forward. Why do we think it's a common method? Why would negotiation be a common method? What do you think would be attractive? Yes, Thomas.
I think negotiations are most common because they allow the parties an opportunity to resolve the dispute in a way that is mutually agreeable to both of them, because they will simply discuss the terms. What have you wronged me, and how have I wronged you, and how can we resolve this thing? And they will come to a resolution that has been agreed upon by both parties.
And then you're right. So the parties themselves are seeking the solution. So there's that opportunity because you're the ones who know what suits you best. Arike?
Yes, my thought was also the same as Thomas's, and I also think because why it's at the very base, and it's why it's the oldest and most common. I think it's because it's the simplest. It does not involve other entities that are not necessarily party to our disagreement. So I think it's the easiest to just resort to in terms when the in terms when a disagreement arises.
You're right, and the simplicity involved, that it's the parties coming to the table and discussing the matters that have led to the dispute. And when you think about that, while you have that at the back of your minds, remember we started off by saying that international relations are really grounded in good faith. So the idea is that you expect that states will be acting in good faith. And if that be the case, then they will want to sit on the table and negotiate and see what could actually be the issue and how they can resolve it and resolve the issue together. Of course, when we say the simplicity of it all, the complexity, of course, sometimes relates to the actual implementation, because you will imagine that you're having state representatives from the different states sitting together and discussing. And of course, there are state interests, and you may have parties that are hardliners and are not really willing to compromise. But the basic idea of good faith assumes that states will want to come to the table and compromise where need be. But definitely negotiation is a key means of settling disputes. The other thing that I would like to also bring to your attention is the fact that, you see, when and even in a domestic setting, people relate with each other on a day-to-day basis. And similarly, state relations are ongoing. So you would not expect that every time there is a dispute on anything, the states will want to include a third party. So the idea is, as states relate, as issues come up, they would sit on the table and discuss the matters. And it's only when they are unable to resolve, there would be need to bring on board a third party and explore the other means of dispute resolution. So we said we've already talked about what is on the screen, that it's always the first step of settling state differences, but it's also a technique for preventing that where it looks like a matter is likely to be controversial or to lead into a dispute, then negotiation becomes an important modality. Of course, when you talk about prevention, what comes to mind is that you're referring to consultation, that states keep consulting each other even as they relate on different matters. The next form of settling disputes, of specific methods of settling disputes, is good offices and mediation. So where parties are unable to resolve matters by themselves or through negotiations, then they may require a third party to break the impasse. So if each state is claiming that there is no way they're going to back down, and sometimes not acrimonious, but each state, because of their interests, is unable to back down or compromise. So when they get to a place where they are unable to agree, then they may want a third party. It could be a third state, it could be an international organization, or it could even be an eminent individual who may try to help the disputing states to reach an agreement. So that can take two forms. It's either good offices and mediation. Now, when you talk about good offices, what you're talking about is where the third party, whether a state or international organization or eminent individual, is really pushing the states to come together. So is sort of guiding each party with a view to bring them back on the table and helping them to come up with a resolution. So the third party will not actually be involved in the actual discussions on the table, but this party that is occupying the good offices will be pushing the parties towards a place of compromise. And when you talk about mediation, the mediator is actually actively involved in the negotiations. However, and I'm using the word negotiations loosely so that it doesn't confuse you. So the mediator would be involved in the discussions and in the parties agreeing on the way forward. And just like in the domestic mediation, for some of you, you may already have had access to information on mediation or may even have been involved in mediation. You will remember that in mediation, the role of the mediator is really to guide the discussion. The mediator is not the one who comes up with a resolution, but the role of the mediator is really to bring the two parties to get into a discussion and guide the discussions with a view of getting a resolution. So again, in a nutshell, when it is good offices, a third party is a go-between, and the role of that third party is persuading the states to enter into negotiations. And when negotiation starts, the good offices come to an end. For mediation, as compared with offering good offices, the mediator is more active and actually takes part in the negotiations and may even suggest terms of settlement to the disputing states. However, I put a caveat that the role of the mediator will not be to force the states a particular way. Their role is to provide that environment or that framework within which the states will come to an agreement. The actual agreement is really a decision of the states, and it really has to come from them, even though they may suggest it is not in their place to force the states to do a particular action or go a particular way. And I want to pause here and ask you whether you have any examples, and I'm thinking particularly of our Kenyan context. Do you know of a situation where we have had either good offices or mediation? And if you're a global reader, do you have any other example? Yes, Thomas.
In terms of mediation, I would like to give the example of something that has happened during our lifetime and we can all relate to. And this was after the disputed results of the 2007 election. Then we had the post-election violence. So both parties were claiming victory. So as a result of that, we had a team of eminent personalities led by the late former Secretary General of the United Nations, Kofi Annan. It mediated the dispute between one side, PNU, that was Mwai Kibaki, and the other side we had Raila Odinga. So they mediated the dispute. At the end of the day, we had both parties coming to an agreement. We had the creation of the Prime Minister's role, and at the end of the day, the matter was settled.
Great, and that's a spot on example. We had actually reached an impasse. It's within the country. It wasn't an interstate, but I think it's a good example of what a mediator can actually do in such a case. So when we've said this, that the mediator does participate in the settlement itself, but leading the parties. Yes, Thomas?
Perhaps I should also give this most recent example of the Nairobi peace process. The Nairobi peace process, which happened a couple of weeks ago, was a negotiation between some of the warring parties in the DRC, most prominently the M23 rebel group. And this also involved government elements of the DRC and also Rwanda, because Rwanda is claimed to be supporting the rebels. So we had Rwanda on one side, and then we had the government of DRC, and then we had the rebel group representatives, and Uhuru Kenyatta was the mediator of those talks. So it was held in Nairobi. It has been called the Nairobi peace process. And I think this is a good example because it happened recently, just a couple of weeks ago. That's when it ended.
Again, a spot on, and this time now referring to states, states being involved. So mediation is a really common form also of dispute resolution amongst the states. Thank you for that. So we said that the mediator may offer concrete proposals for settlement of substantive questions. So the mediator leads the discussions. But as I've said, the decision, or really the agreement, is really for the states to make. And of course, as lawyers, a good mediator will frame issues in a way that will lead to a constructive discussion. That even in the day-to-day discussions, even between individuals, that if you don't frame the questions or the issues properly, you may have potential for agreement. But because you did not lead the discussion in a manner that will be constructive, you let the parties talk about non-issues, or you're unable to frame the very contentious matters in a way that will be constructive, then there will be no solution. So in the same way, the role of the mediator is really to guide these discussions in a way that will lead to a constructive end. That in the domestic setting, when you're training mediators, that's part of the training. How do you get parties who have different interests to really come to a central place where they will be able to address the key issues and have a constructive end to the matter on the table? What I'd like to emphasize is that the product or the agreement has no binding force on either disputant. So the mediator has led the parties to that agreement, but again, the enforcement is a question of goodwill. But the argument is always that when you have led the parties to an agreement, because it is by consent, they have come to an agreement, then it's expected that they will implement on good faith. But it does not have a binding force as it would when it comes from an adjudicative body. So the other form of dispute resolution is inquiry. And the role of inquiries is really to fact find. You understand that a lot of times disputes are as a result of misunderstanding. So inquiry becomes important because you want to find out what exactly happened leading to the dispute. And therefore, inquiry is then considered as a mode of settling disputes, because it's out of that determination of the facts that is expected to lead to a resolution of the issues. A good example, and I will call on you to look at, is on the Korean airline flight, in which the International Civil Aviation Organization, ICAO, was involved, and the SG was sent to inquire into the matter. I don't know whether there is anyone who has the facts of this. Does anyone know of this, the Korean airline? Does anyone know about the Korean airline and what happened? Has anyone heard about it? Anyone?
May I go ahead?
Yes, please. Yes, who's that? Yeah, please.
Oh, okay. So just a very brief understanding of that particular case, the Korean airline flight. I'm not sure if it's the correct one, but maybe you could direct me further. From what I remember, I think that particular flight was scheduled to travel from one city to another. I believe it's from New York City to, I think, Seoul, if I'm not wrong. And that's like, it was supposed to pass through a particular country. I believe it was Alaska. And then, you know how, like, when it comes to aircrafts and flights and the likes, there are usually mistakes that may happen and technical hitches. And the one that I remember is, I think, something to do with the navigation. So this particular flight drifted from the original, what's it called? I think pathway or original route that it was supposed to take. And it ended up going through a prohibited, I think, airspace or airport. And it was during something to do with, I think, the reconnaissance or something of the sort. And so since it went through a prohibited air area, then I believe it's the air forces that are based in Soviet. They now treated this particular flight, I think Korean airline, as an intruding, like it's more like a spy plane because the area was prohibited. So for them to see a flight coming in that wasn't supposed to fly in, then now that's what happened. I don't quite remember what happened, but I think those could be maybe the brief facts of the case. But I'm aware of another incident of where I think one of their flights, like the Korean air flight, was ordered to pay one of their flight attendants a particular amount of money because this particular flight attendant was subjected to abuse. So I don't know which one in particular you might be referring to.
It's the first one. It's the first one and really spot on. Thomas, I saw your hand as well. And those are actually the facts. But Thomas, would you like to add?
I just want to confirm what Chelsea has said. Basically, the context of the shooting down of the Korean flight 007 was that it happened in 1983, and this was during the height of the Cold War between the United States and the Soviet Union. This was a period of a lot of tension. So it happened that this flight, I think it was headed, I can't recall where it was headed, but it deviated from its flight path and entered into territory which was considered under Soviet protected control. As a result, since there had been no communication, and then the deviation itself was a mistake by the flight crew. As a result, since there had been no communication, the Soviet military thought it to be an enemy plane, maybe conducting some espionage or whatever they thought. Therefore, they decided to shoot it down. But the context is in 1983, and this was during the height of the Cold War between the United States and the Soviet Union.
And that's really, really spot on. You've provided the context, both of you. And so we're bringing it back to our discussion just to understand what actually had happened before discussing or agreeing on way forward and to settle this dispute. The Secretary General of the International Civil Aviation Organization was sent to inquire and find out what exactly had happened. And I think this case is a good one in terms of showing the importance of inquiry, because you can imagine the argument saying, it came to our territory, and the argument, well, it wasn't intentional. So the whole discussion of what exactly happened is critical in solving this dispute. The other mode of settling disputes is conciliation. And in conciliation, you refer the dispute to a specially constituted organ whose task is to get the facts and suggest proposals. It's both a combination of mediation and inquiry. Again, just like mediation, the proposals of conciliation have no binding force on the parties, and the conciliators may meet with the parties either jointly or separately. You remember with mediation, you have the mediator meeting with both parties, but for those again with information on domestic mediation, you recall that you may sometimes what we say caucus. When the parties are unable to come to an agreement, you may suggest to caucus with each separately and then come back jointly again. Conciliators may actually just meet with the parties jointly or they may meet separately. So it has a mix of both mediation and inquiry. Again, whereas the main object of conciliation is to provide the active services, or rather just to follow it up, that conciliators may meet either jointly or separately. And the main object is to provide the active services of a commission of parties in bringing the parties to an agreement. So similar to mediation in that sense. But it differs from arbitration and judicial settlement. The parties are under no obligation to adopt the proposed settlement, whereas a legal obligation does exist when it is an award or judgment from a tribunal, so to speak. So again, the difference here being that it's non-binding, but also you notice that the other difference with conciliation and mediation, the parties are actually more involved in agreeing or in coming up with a solution, as opposed to conciliation, which is more of a direction of what, or a proposal, what needs to be done, and the parties can either accept it or not accept it. Arbitration, just like in the domestic setting, an arbitrator is appointed to act as an adjudicator. And it is said that modern arbitration begins with the Jay Treaty of 1794, of course, a very old time between the US and Great Britain. And it provided for adjudication of various legal issues by mixed commissions. So it wasn't a single arbitrator. So you have mixed commissions providing the services of arbitration. The decision-making in an arbitration is designated to the arbitral tribunal. So this tribunal is created to deal with a particular dispute or class of dispute. And this is important so that you're having expertise on the matter. And again, borrowing from the domestic setting, when you look at arbitration, you will see that arbitrators develop expertise on specific matters. So you'll have those who are, who are experts in particular fields. So there's that level of expertise. And that's one of the reasons why one may opt rather than to go to a court which is not specialized, to an arbitrator who is specialized on a matter and therefore able to perhaps comprehend and assumed to give a good decision. So the tribunal makes the decision and requires the party to adhere to it. Arbitration can be defined as a procedure for the settlement of disputes between states by a binding award on the basis of law. And that's important, a binding award on the basis of law. And as a result of an undertaking voluntarily accepted. And I want to pause there. I don't know whether you're being interrupted by the call in my background. I think it's over. But I'd like to pause there and ask this question, that here you have two scenarios. You have the adjudicative body, a court, so to speak, and you have an arbitrator. And for the arbitrator, they do provide a binding award on the basis of law. What then would be the distinction? Why would states, for instance, opt for an arbitrator? And if you're saying it is binding, what would you think would ensure that there is enforcement? Remember, as we keep talking about and in the international realm, that the enforcement mechanisms are really not there. So thinking of arbitration, when you say it is a binding award, how would we ensure enforcement? Or what do you think really is what promotes the enforcement of that award? And I don't know whether my question is clear. So in other words, you're saying there is an adjudicator in this case, an adjudicating tribunal. They've given a binding award on the parties. So what guarantees enforcement? Because you're using the word binding, but this adjudicating body, this adjudicating tribunal does not have means to enforce. What do you think is an award given by an arbitrator?
I am not so sure, so I'm not so certain about this answer. But I would like to fall back to the principle of pacta sunt servanda, or good faith in how nations relate to one another. In addition to that, I would like to mention the various means which can be used whenever a country goes against a binding charter or a binding agreement. For example, it can be removed from membership of a certain organization. Let's say the United Nations can be suspended. Apart from suspension, where it's about two countries, there could be stuff like diplomatic protests, where a country having chosen to go back on its obligation arising from a certain agreement, then the other country can decide to withdraw its diplomatic mission from that country as a sign of protest. Or where it is a very serious breach, then maybe the international community could come in with stuff like sanctions. But otherwise, I would first like to insist on the issue of pacta sunt servanda, where nations transact.
Yes, and I think you going back to that very first point is spot on, but I can see somebody else who wants, yes, Arike?
So first, I agree with Thomas that we've already discussed severally how one criticisms of international law generally is that its enforcement mechanisms are not effective. And we say that it just relies on good faith. And usually there's that quote that usually states will abide by the obligations. And so if this is a binding award, then based on just what we've learned so far, the states will mostly abide to that obligation. But then as I was researching on this topic beforehand, I found that the UNCITRAL, the International Center for the Settlement of Investment Disputes, they have, there's a binding arbitration rules. They have rules where if a party is successful and they are given an award and the other party fails to do that, then they can seek enforcement of that award in domestic courts. So I don't know if this applies to all arbitration bodies, but I know specifically for this one, they can seek other forms of enforcement if a party refuses to abide to the award given.
Yeah, thank you, Arike. And perhaps I should start off with your last question on the UNCITRAL rules, which is really the framework that provides the international legal framework for arbitration. And that framework is where we draw our arbitration laws in Kenya and other countries as well. So the UNCITRAL model provides the model law for arbitration. And indeed, it does has issued a judgment, quote unquote, then an award, then parties can seek enforcement. But back to the state, when it's with regard to states, the arbitration between states, the fundamental point becomes what both you, Arike, and Thomas have alluded to, the issue of voluntariness, because it's the states that agree to subject themselves to an arbitrator. on a tribunal, an arbitration tribunal. And by virtue of that, it is again expected, and as we keep on saying, that even with treaties, that when a state has consented to a treaty, then it is expected as a matter of good faith to comply. So in the same way, when both states subject, and I'm saying both, it could be more states, when the states agree to subject themselves to an arbitration tribunal, then it is expected that they will adhere to the findings of the arbitrator. So the fundamental point being, again, just like with all other international laws, the idea of good faith is really at the center of this all. And remember, the philosophy of peaceful settlement of disputes. So the objective is clear, the philosophy is clear, and the assumption is that if then you have accepted to subject yourself to this tribunal, it is then expected that you would adhere to the award. And the suggestion of enforcement that countries that don't adhere to their obligations in the international regime, then it means they also subject themselves to sanctions from other states. It does be expected to adhere. Of course, you will have a few here and there that will not adhere, but the assumption is that the fundamental principle is on good faith. So arbitration has been used just also to highlight by states, and it's considered an effective method in view of the number of cases and have been settled in this way. And there are many reasons why this is the case. One is, as we are saying, you have experts dealing on the matter. Number two, again, the issue of voluntariness, that the states subject themselves voluntarily, which even means their cooperation as the process goes on is higher. If you look at the ICJ, and just like in the domestic setting, where you have the court overwhelmed with the number of cases, but where you have arbitrators having fewer cases, and therefore available, then meaning the cases are settled speedily in comparison to going to a judicial body. Consent, and I have already spoken to this, so I will not belabor. Consent is just like in the domestic setting, it is a prerequisite that consent has to be issued by the states before arbitration is actually taken on. A point to note is that consent can be on an ad hoc basis or based on a treaty. So the parties, when they came up with a treaty, could actually have included an arbitration clause indicating that if there is a dispute arising, then we would seek services of an arbitral tribunal. However, it could actually be when the dispute arises, the parties agree, let us subject ourselves to arbitration. And that's the same in the Kenyan context. So again, increasingly now, when drafting contracts, parties are including an arbitration clause stating that before parties go to court, they will subject themselves to an arbitrator. But it could also be the contract, the domestic contract did not have that clause, but when a dispute arises, the parties opt to go to an arbitrator. So similar to the international context as well. The identity of the arbitrators, the formulation of the question to be submitted to the tribunal, the rules of law to be applied, and the time limit within which an award must be made, but also must also be mutually agreed upon by the states concerned. Such issues are spelled out in a special agreement, which is known as the compromis. so the parties will spell out the issue. So what is the real question that we want an award or a decision on? What are the rules of law? Is it both international law and are there aspects of domestic law, etc.? So those terms are clearly included in the special agreement. Party autonomy, that arbitration is a device for leaving the settlement of disputes as much in the hands of the parties as is possible. And I think this is an important distinction. Think about it. When parties go to court, what usually happens, and in this case, when states go to, say, the ICJ, there is not much control because they will present their side of their story, so to speak. They will present their arguments, and the court then decides how everything will go. But with arbitration, as we have seen, that even framing of the issues, it's something that the parties will agree upon. The idea is, yes, you have an arbitral body or tribunal that will agree on the matters, but the parties are really involved in framing, and there is a lot the method of settlement, including the place where the dispute is to be settled by whom. So you actually choose who is the adjudicator, which is the arbitral body that we will adjudicate on this matter, and in accordance with what procedure. So very similar to the domestic setting, party autonomy is actually one of the key principles in arbitration. A few distinctions that we may already have started speaking to, but just to emphasize. One, with arbitration, there is party autonomy. With a court, not much control. Once you put the matter for a court, then it's the court that runs the dispute resolution, and it's the court that will make the decision. Judges of their own choice. In a court, you cannot choose with a judge that you will want to hear the matter. The states cannot choose. But in arbitration, the states do make a decision who will be the arbitrators. And we already talked about specialization. Arbitrators, in most cases, are experts in a particular field of law. So, for instance, if the airline case that we were talking about was to go to an arbitrator, they would probably want somebody who is an expert on aviation law. At an arbitration, an arbitral body that specializes on international aviation matters. Confidentiality, arbitration sits in private, whereas courts sit in public. In courts, the records of the court are actually public documents. So even in the domestic setting, one of the selling points of arbitration is that you do not expect that your case will be reported somewhere with the details. So similarly, states like arbitration because of the confidentiality that comes with it. No appeal. I think this is an important one, that ordinarily, because parties have consented and because of the party autonomy and party involvement in the process, the idea is that whatever award is given, it should be final because you've been part of the process, and the outcome is expected to be serving the interests of both parties. Similarly, in the domestic setting, when parties go to arbitration, the arbitral award is final. However, in the domestic context, there has been instances where appeals have been allowed, and appeals have been allowed because of procedural issues. It's not the substance of the matter, but it has been because, for instance, where an arbitrator is allegedly involved in fraud, has been bribed, etc. So matters that would really have affected the justice, so to speak. Effective enforcement, the Convention on the Recognition and Enforcement of Foreign Arbitral Awards applies, and this is one that you should look up. With the issue and taking us back even to the UN Charter on how do you settle, on how do you ensure that states do comply with their obligations under international law. I will pause there just in case there's a question or comment before we move on to resorting to regional arrangements and other agencies. Any questions or comments? Right, so this one is just by way of mentioning that there will be instances in which states will resort to the regional arrangements, where you're talking about, for instance, we were talking about the the framework within the African Union or the framework within the European Union, and states will then take their disputes to these frameworks for or guidance on the disputes, on how the disputes should be resolved, or how the dispute should really be resolved. We then look at judicial settlement, and I think we've even spoken on this as we went along, so we may not belabor too much on it. But this really refers to where a dispute is submitted to a pre-constituted international court or tribunal, which has independent judges whose tasks are to settle claims on the basis of international law and render decisions which are binding upon the parties. I would want to emphasize, and we've already alluded to this, that with the arbitration, because of their party autonomy, they will even decide which law is applicable. But under the international framework, the judicial bodies will settle disputes on the basis of international law and render decisions which are binding upon the parties. Article 92 of the ICJ, Article 92 of the Charter, does indicate that the International Court of Justice shall be the principal judicial organ of the United Nations. And it does provide an annexed statute which then gives more details about the operation of the ICJ. We already talked about this. Remember when we had the groups talking about the ICJ, and I do not want to belabor this because we already talked about it and the group did present on it, but I will of course provide this these slides for you to refresh your memories on the court. But just a few highlights that the court has a set number of judges, 15 judges, and the qualifications are indicated in the statute. But I think what is important for you to note in this context is that the court should not include more than one judge of any nationality. And I want to just contextualize this and ask you, why do you think the issues of nationality is important with respect to composition of the court? Why is it important to ensure that you don't have more than one judge of one nationality? Anyone? Mike?
I had raised my hand on a previous question, but I could try.
And you could do both. You can answer both. You can speak to what you had raised your hand for and also for this.
No, I think it's to do with the impact on the judgment in terms of bias, and you have when it comes to giving the judgment, then you have more judges agreeing to a certain point, to a certain side than the other. So the issue of I would say more so of like voting. Then if you have judges from leaning to certain area or more on a certain country, then it will impact on the judgment that the court will give. Just trying on that sense. And my question was on what happens if one of the states refuses to acknowledge that such a judgment from the ICJ, for example, as it was the case with our maritime dispute between Somalia and Kenya.
Yeah, thanks, Mike. And I'll just comment on your question and then allow the others who have put up their hands on this matter of the composition of judges to also comment. The enforcement of either awards or enforcement of international law generally takes us back to the general enforcement of international law. You remember, by starting off and saying enforcement is one of the challenges of international law, but that does not mean that there are no means to secure enforcement. The idea is that states want to force a state which has erred to do what is required of them and for them to meet their obligations. So the means of enforcement go back to the same means that we have been talking about. So where you have sanctions, are they economic, are they political? So we go back to those, and it requires the international community then to apply those sanctions as well. There is no other way. It's just really the international community acting in a manner that will force the state that has failed to meet its obligations. And similarly, it could even be the state that has a dispute with the errings, with the state that has refused to honor its obligations. It could be that state now also putting sanctions if they were, for instance, having economic arrangements that benefit the state that has failed to meet its obligations. It could employ economic sanctions. So it takes us back to those general modes. And I think an important point is the framework of the international community is important. So where the international community is aware that a state is refusing to honor its obligations, meaning that it is not actually acting in good faith. So it could even be the other states, even though they were not involved in that particular dispute, also going on to, in support of the state that has been wronged, to secure enforcement by all. Right. So I'll allow I think there was Thomas and Chelsea. We start with Chelsea for your comments.
Yes, Doc. And maybe just to get your question clearly, I've been having internet issues. Does your question relate to the composition of the courts, specifically on how there are 15 judges and they must be of high moral character? And the third point, just to confirm.
The nationality, and in particular, just to get a sense, why is this important? Why is it important to spell out that you should not have more than one judge of any nationality? Chelsea?
Can I go ahead, Doc?
Right.
Yeah. Chelsea, did you want to say something before Thomas does? I think Chelsea's having, Chelsea, I think you're having technical challenges. But we could start with Thomas first and then come back to you. Yes, Thomas.
Okay, so I would like to respond to both questions. The first question on why there must not be two judges from one nationality. And then I come to the question of Michael Mbaru, whereby in case we have one party, state party, not acknowledging the judgment of the ICJ, what happens? So on the first question, why we should not have one judge of more than one nationality, I think this highlights there is need to reflect the international nature of the court, number one, and also to insist as much as possible on the impartiality and neutrality of the judges. Given that the court itself is of an international nature, serving within the realm of international law. As a result, if we were to have more than one judge representing a single nationality, the element of impartiality and neutrality would be compromised. As a result, these rules come in to ensure that the objective of neutrality and a reflection of the international nature of the court is geared towards as much as possible. That is my answer to the first question. Meanwhile, on the second question, I would like to refer from a case that Doc you mentioned here in a very nice way, I think 2 classes ago. And this was when we were talking about diplomatic immunity, whereby we looked at the case in Iran when some students were protesting and they invaded the US embassy. Then the Iranian government, which has power under the United Nations, under the Vienna Convention on Diplomatic Relations, to protect the inviolability of this diplomatic mission, actually made statements which amounted to supporting the students who were protesting and who had taken hostage those diplomatic staff. When this matter went to the ICJ, number one, Iran refused to provide certain very important materials which would have acted as evidence. Number two, Iran refused to participate in those proceedings. On the other side, the United States, having taken the court to the ICJ, also sought to have damages paid to them. At the end of the day, judgment was issued against Iran that it had failed, according to the Vienna Convention on Diplomatic Relations, to uphold its responsibility of protecting the inviolability of the diplomatic mission. However, the enforcement measures were somehow weak because there was no way this court went ahead to impart, to make sure Iran observed this judgment. What happened then was trying to have the United States, through its influential position on international relations, trying to come up with measures that somehow push Iran. For example, we realized at the United Nations, there was some cold way in how Iran was being dealt with, and much more we have seen up to until this moment. We still have issues between the United States and Iran, but it's more of covert means from the United States trying to impose sanctions on Iran, trying to have Iran simply trying to make use of its international influence to send or to punish Iran. But there are no really strong means through which that issue was dealt with. Yet the judgment was rendered and Iran refused to partake in those proceedings.
Thank you, Thomas. And I see that I think it's Arike that still has her hand on, but that's spot on and we'll come back to you. But I want to hear the others first and then we can conclude. Arike?
Yes, thank you. So while I do agree that the impartiality of judges is one of the reasons why the International Court must have just one judge of one nationality. While my group was researching these questions, we came across some other issues, and it's on impartiality, not so much because one country should have just one judge, because then the judge will be impartial, because they can only judge on like whatever their country, if their country is before them, then they can only give, their vote will only be one, but sometimes their country will not be before them. So the issue of impartiality does not really come in, because they can be impartial to any country. But also there's the issue of interest. This was especially true in the times of the Cold War, when socialism and democracy, meaning not socialism, communism and democracy were really at war. So meaning it was basically the US versus Russia, and like the Soviet Union. So the court, the research found that judges had leanings towards one side, and some of them were communist and some of them were more towards like the liberal way of thinking, the democratic way of thinking, and presented cases before them, and they would judge based on that. Not 100%, but that would impact their decision. And so the research went ahead to find the agreeableness of states based on these decisions. And so the court found that when the states were presented with decisions where the leanings were divided, so that not more judges leaned towards one side versus the other, then it's easier for the states to accept the decision. So that goes back to this idea that justice should be seen to be done, even if like it could be done, yes, but if the state does not feel that justice was done here, then it could be a problem. So in the issue of that bias, I think it's important that even if sometimes the state before the court is not like the state before the court has a judge there, yes, but also that their interests are being taken into account by that judge. And so it's easier for the state to accept that decision if they feel that there was no biasness in the point of the judge. And even if there was, then there was a balance between that, because some other states were also like on their side. You can take the question of like if maybe African judges are not sitting there and only European judges are sitting there, but the case is not necessarily like any of the European countries. It could be like the judges who are sitting there, they're not really, it's not like two judges sitting there who are from the UK, but African countries will still feel like there's no African on their bench. And so the interest of the African is not really being taken into account. So the idea that states are more likely to accept a decision if they feel that the decision was fair, and states are more likely to feel that the decision was fair if they feel that no side got their interest taken more into consideration than the other, is what this research was saying, and I tend to agree with that.
That's a very interesting perspective, and I think it's good to hear that view as well. Thank you for that. And I think Chelsea is back as well. Chelsea, do you want to?
Yes, I sincerely apologize for that. But just going to what you have asked, for me also, I would draw away a bit from the issue of impartiality. And I don't know if this was mentioned in my absence, but then I would bring in the issue of diversity, because there was an article that was written by someone who works for the United Nations Office of Drugs and Crime. And they noticed that when it comes to the issue of diversity, now in regards to why the court may not include more than one judge of any nationality, there was the issue of diversity in that, bearing in mind that the judges are of different, nationalities, then automatically the level of judicial thinking and their perspectives are a bit different, because I believe maybe in their different, nations and whatnot, they have experienced different situations and they have handled them differently. And this article is just saying that when it comes to diversity and the judiciary and the court, it tends to produce better justice. And there's also the issue of them being from different backgrounds, because now with diversity, it means, one judge will challenge the judicial thinking of another, at the same time enhancing another judge's perspective. And I was just still on the same article. There was, I think the former CJ of Canada was talking about, the whole issue of practical importance of diversity. And, she was just emphasizing how this whole issue of diversity sort of strengthens the judicial system. So just as I wind up, the issue of diversity seems to be quite key, because them being of different nationalities means that their thoughts and opinions on different topics will be different. And then also they talked about how, diversity also sort of increases the public confidence in the judiciary, because in Kenya, we have seen how the public at times is not confident in the judiciary and how they handle things. So I believe, just relating it now back to ICJ, if there is diversity, if their judges are of different nationalities, then now the public at least has confidence in the judiciary that the judgment that will be given would be different in a way, and it wouldn't really be biased or will not really favor one particular group over the other. And as I finished, I have a question that just came across my mind. I've just seen the slide saying that the court consists of 15 judges of high moral character. And my question is, what is the test? What is the test of, high moral character? Do they have to be religious, or do they have to have a very good criminal record? What is the test when it comes to measuring the moral character of the 15 judges that are appointed to serve in the court, I believe?
Yeah, thank you, Chelsea, for that. And I think the three of you raise very pertinent issues. And starting from the issue of diversity is critical, not just in terms of reiterating that it is an international tribunal, because of course, if you want to give the court an international face, then it's important that you do have representation from different nationalities. And remember, and probably I belabor this too much, where you're saying, states are sovereign, states are equal, etc. The idea is that if you had, say, judges coming from one state, is there a suggestion that a particular state is more deserving than others? So the question of just having representation is important. But it's also important, and I think Chelsea, you've alluded to it briefly, and you can pick, for instance, with the International Criminal Court, one of the things that has been positive with the International Criminal Court is that it's able to fuse the civil system and the where you have in our current system. So you have two systems at odds. Those who come from a system that judges investigate as well, how do they, what is your legal system? So the fusing of different legal systems does ensure that we pick the best from each system. So there's that sense in which representation adds value to the court. But I think the question of impartiality is also not remote. I think the aspect of impartiality is also important in this regard, because if you say have judges from 3 judges from one country, chances are if there's a matter that relates to that country, that it's impossible to have a panel that will not consist of a judge from that country. So it's important that you have wide representation so that even the event a country has a matter, it's possible to have a panel that will not include, but also that you're saying if there's a particular philosophy that is carried by judges from a particular country. Of course, the assumption is that when they come to the court, they will adhere to the rules of the court and the philosophies of the court, but you cannot discount philosophies that underpin countries' justice system, and they may carry it to the court. So the idea of a balance is really important, and I think it speaks to impartiality as well. So very interesting points from all of you. But what I like about this conversation is that it really shows the kind of discussions or the kind of skill that we would like you to have at the end of the day, that you're not just repeating what is in the books, but you're also able to argue out points, and that is expected of you when answering questions, when you're asked to discuss, and even as an advocate later on, that you're able to critique and argue both ways. But also just to reiterate, I think it was Thomas's approach, where you are bringing in the Iran case. And just to remind you that as you argue out your points, it's important to have case law and statutes that you make reference to ensure that your answers are grounded. A lot of times students will know the principle, but they have no backing. And as a lawyer, if you cannot make reference to the law, you don't make reference to cases, then your answer will probably just enable you to pass, but pass dismally. How one does very well is where you're able to back your answers with case law and statutes. And a fundamental question, Chelsea, about the high moral character. In fact, we were just discussing with my colleague, Dr. Deche, that just the other day, on a paper that she's submitted to a journal on the integrity test, even as you choose judges in the Kenyan context. And of course, the question of moral character is subjective, but there are certain benchmarks that will usually be used. Number one is the question, whether somebody does have a criminal record. Are there complaints of corruption? And so, whilst it is subjective, it is not a fluid discussion and just saying, what is moral, what we think is moral goes. They will be taken through tests as states negotiate which country will give a judge and which particular judge will actually end up on the bench. They will have done investigations and open it up for individuals and countries to submit reports on individuals. So the point being, the test of morality and integrity is of course problematic in the domestic setting as well as the international setting. However, there are those benchmarks that we all agree on. If somebody has a criminal record, that casts aspersions on their moral character. If somebody has been alleged to have been involved in corruption, that does again impute or suggest that they are not of a high moral character. Moral character is also linked to professionalism. So if you have somebody who has a track record, if they were a judge in a country where they do not conclude cases, that will cast aspersions on their morality, because high moral character does affect our professionalism. You would not be taking a salary if you're not meeting your obligations as a judge. So a roundabout answer, but I think the point that I'm making is that there are those benchmarks that are there. But of course, there will be a lot of extraneous matters that are discussed depending with each individual and what comes up when it's opened up for reports to be submitted. Does that answer your question, Chelsea?
Yes, it does, and I appreciate for that. I mean, I appreciate you for that, rather. And it just brings my mind to, like, it opens up my mind to even more questions. And just posing this directly, does the issue of religion affect, the integrity? Because people tend to believe that, when it comes to Christianity, if you're a staunch Christian, for example, like Court of Appeal Judge Mutunga, then automatically you are considered to be a judge of high moral character. So maybe if you could address that just as a follow-up, that would be good.
What's interesting is that if you're to talk about the ideal, is the issue of religion is considered. If you brought in the issue of religion, it could be said to be an issue of discrimination. If you look at Article 27 that talks about non-discrimination on the basis of religion, etc. So if you were to say that you think somebody is of a more high moral standing because they are a Christian, then other applicants would argue is in that discrimination, that you're discriminating against them on the basis of religion. And to be honest, in our country, we have seen many people who speak out as Christians, but not necessarily have conduct that places them on a high moral plane. So I think the issue of religion is not, and especially I would almost say at the international level, that would not even be an issue of discussion. I think the question is, if I may follow from the Christian perspective, it's the fruits. So yes, you're a Christian, but whether you're a Christian is neither here nor there in that discussion. What people will look at is if your Christianity, if your religion as a Muslim has made you a person of high moral character because of how you conduct yourself on a day-to-day basis. It is the conduct that we look at as opposed to relate it to religion. Having said that, what I always say is that the law does not operate in a vacuum. So this is us speaking as purists, as lawyers, that the religion is neither here nor there. But the truth is that a lot of people will judge you based on how staunch you are or not. But when you think about it, and from a legal perspective, religion is really not a consideration. It is more a consideration of your character and your track record.
Right. Thank you very much for that clarification, Dr.
Right. So that brings us to the end of that discussion. And as I said, I do not want us to belabor, because we've looked at the composition of the court when we were looking at the different organs of the UN. But I would welcome will come in when there are contentious cases where there are disputes, but measure as well. So where states can foresee a dispute because of a matter that's not clear, the ICJ is available to provide advisory jurisdiction. So of course, and unless you would want us to go through this, but these are discussions that we already had when we were having the discussion on the court. I don't know, I would want actually to propose that I provide the slides, and when we come in tomorrow, if there are any questions on the court, because we had already discussed this, then you're welcome to raise the questions in class. Is that a good way to proceed? Yes, Chelsea.
Yes, I believe that's a good way to proceed. And maybe because you brought up the issue or the story of slides, I don't know if this is a request that you might consider. Maybe you could also share with us the slides that you have been using for the previous classes, just as a guide. That way we know what to focus on and what not to focus on. That's a very, very kind and humble request.
No, I actually, unless it's just inadvertent, they actually are supposed to be part of the materials I share. So I'll go back and see which slides I haven't shared for the other topics. But that's a standard I'm happy to share slides.
Yes, and maybe just to follow up, there are slides that you have shared with us, but then I believe at some point some of the slides are missing. So maybe just as you have said, I think that could work out. Okay, thank you.
Okay, great. I've seen two other hands. Who is it? It's Michael, and then Arike.
Thanks, Dr. Mine is a question which I may think it would have been a good question during constitutional law classes, but then I didn't have that question then. Last week I was involved in an international meeting in the maritime sector, and it was more of climate change discussions and negotiations of climate change. Then it happened that I met some representatives from Tuvalu, Marshall Islands, and so forth. So they had issues, and they wanted more ambitions in terms of dealing with climate change. And they said that they are at risk of losing their statehood because their islands are submerging. So my question is there any criteria? Because there is a criteria for statehood. For example, you have a defined territory, you have someone who rules that territory and so forth. So is there a criteria for losing statehood? I believe that the question is also proper in this unit.
And that's an interesting one, Michael. And the beauty of international law is that it organically develops. And I can see Thomas is also raising his hand. But I think and even as I allow them to also say, is that, you see, we tied the question of statehood to also recognition as well. So here is a situation where a state has all the markers. So they have the defined territory, they have the population, but now the territory is reducing. So the territory reducing would not necessarily means that it loses its statehood. It actually just means that it's a state that has a reduced territory. What would be interesting, though, and I'm just thinking that's a really interesting situation where the entire, territory is the entire island is submerged, so that the population is no longer. I think it's a practical question. So if it's completely submerged, they would no longer be staying on that territory. And I think at that point, then one could say that, where are you even exercising your authority over if all your people have to move and are no longer on the territory? But I think that's an interesting discussion. I think the question of losing statehood is a question of whether the markers of a state are still in place. But let's hear first from Thomas, I think, who was raised.
Before the rest come.
Yes, please.
Actually, that was the issue. They have foreseen that in few years to come, because some of their islands, especially those that are not occupied, have already submerged, some of them. So actually, they predict that in few years, those are that will actualize, and that completely. And they were saying they have already started. People have already started moving to other countries and try to get settlements in other countries.
Yeah.
And you find that in Marshall Islands, they had a census recently, and they found that majority of the people from Marshall Islands are not living in their country. They have relocated to other countries. Like more than half of their population was counted from different countries. And the issues of, now when it comes to maritime boundaries, there's that measurements from the coastline, the EEZ of other countries now, because the island is submerging, the situation will come where the EEZ of other countries are extending to, the island that has submerged based on the delimitation of maritime boundaries and so forth.
Yeah.
So actually, that was the issue they were raising.
And I think that's very interesting, because I think if it has submerged and everybody has to move away, then you no longer have effective control on a population. So you really do not even have the markers of a state. And that's, I think that's something you should consider for your research paper, Michael. I think that would be an interesting one to write on. And I think because it's timely, because it ties in issues of climate change as well.
Yeah, actually, I've started developing the concept of it, but I'll come to you for more guidance.
Yeah, that's an interesting one. Thomas, did you want to comment on it?
Yes, I wanted to say something in regard to Michael's question. First, I would like to acknowledge that it's quite an extreme and maybe weird question, because what we have learned so far is how a state may lose a certain part of its territory or acquire new territory. And I think this is one of the questions that a number of our colleagues, not in my group, but another group, dealt with, on how a state can either lose or acquire territory, because territory is one of the components of statehood and also sovereignty. You must have defined geographical locations. And one of the means through which territory can be acquired, we said, is accretion. Accretion is whereby territory is either acquired through an act of nature. For example, we could have, for example, within the 12 kilometers or within a certain area, an ocean as a result of climate change could dry up. And when it dries up, it creates an island, which is within an area that can be said to be part of a certain territory. As a result, it becomes part of that land, that already existing territory. And then the existing territory can exercise sovereignty over that new land. So accretion is one of the ways through which natural occurrences or an act of nature can cause an already sovereign state to acquire extra territory. And I would like to point Michael to a case. And this case was under arbitration, and it involved the Rio Grande River. The Rio Grande River is basically the one that is the border between the United States and Mexico. There was a time when it flooded, and when it flooded and then the water came back, a certain body mass of land was created. As a result, there was a dispute as to who owns this new land that has come as a result of now. We had the river, which was the boundary. But now the river it flooded and then dried up in a way that it has left a certain land. It has created a new land. Who owns this land? The flooding of the river was taken to be an act of nature. When the matter went to arbitration, it was decided that that new land was part of Mexico. So I am applying this method of accretion as a natural way through which natural causes can result into acquisition of extra territory. However, Michael's examples is quite unique because now we have an act of nature causing the reduction of territory to the extent that it is diminished completely, and we are no longer talking of any control, any sovereignty, any statehood. It is lost. But that is the example.
Yeah, and thank you very much for that example, just giving us the polar opposites. But I think that's very useful information. And that Rio Grande River case is an interesting one. And I think, as you rightly say, Michael's case is one of those interesting things that we probably are going to see in our lifetime. And that speaks to how the law develops. It's alive. It doesn't die. It goes on developing. Arike?
So, first of all, I'd like to acknowledge the fact that Michael's question is really interesting, especially given how we are moving, like with climate change, especially. It's been estimated that part of Netherlands has already sunk, but it's not likely that Netherlands is going to lose its territories because they are doing something about it. They're maintaining their coastal defenses so that even if the land itself has sunk, then whatever has come now becomes part of their territory. So it's just a wonder if a country is going to have a territory that is based entirely on water, so that it's not necessarily that they've lost territory, they've just lost land. So that's a really interesting question, I think. It's even, again, the question of we already said that population does not matter the population, the quantity of the population that you have. But then what of cases where you have these mass migrations? For example, it's been estimated that from Venezuela, 7.3 million people have migrated from Venezuela because of the instability in the country. So if the numbers keep increasing, then what happens in the end where a country does not really have effective control over a significant population, and even the population that they do have, they don't necessarily have effective control over that. So do they lose statehood then? So I think Michael's question is really interesting, especially when you broaden it in terms of what is happening in climate change, what is happening with the mass migrations that are going on based on just what is happening realistically. But my question was, in terms of declarations, while we were doing our research, we found these declarations on friendly relations, declarations on decolonization. I was wondering if declarations are just binding on themselves without ratification. Are they just an interpretation of the document? For example, the declaration of decolonization refers you back to the UN Charter. So is it that if you have signed to the UN Charter, then automatically whatever is in the declaration is simply an interpretation of what is there in the Charter? That was my question.
And that's a really important question because it speaks to matters of soft law, matters of binding nature of international law. Are all legal instruments of the same power, for lack of a better words? Are they of the same? Would you say they are on the same level? Are there levels when it comes to international instruments? And the answer to that is that, of course, conventions and treaties ratified by states are directly binding on the states. Now, with declarations, they speak to what states have agreed on as the developing law. And I'll break this down a little bit more. So we had the Declaration on Human Rights first. So speaking to where are we heading in terms of accepting principles to govern states. But the declaration by itself does not provide the force of the binding force of law that is required to impose obligations on the states. After the Declaration on Human Rights, you had the two conventions: the Convention on Civil and Political Rights, and then the Convention on Economic and Social Cultural Rights. So these conventions now, when you look at them, what they do is pick the principles set out in the Declaration on Human Rights and now binding force to states that ratify the conventions. So that is to say that the declarations do not give the binding nature of international law. However, they are not useless, and they still have a force in international law. And the force is this: there are two things. Number one, they signal the principles that states have agreed upon as the way to go. But number two, when you talk about the customary developing international customary law, if you look at what already is constituted in declaration, that could actually be a signal of states having agreed. Remember where we were saying there's the opinion juris, but also the practice, and states agreeing to have been bound by a particular practice. And so when you go back to a declaration and a particular provision is already existing in a declaration, that speaks to to principles that states have already agreed to, and it speaks to the opinio juris. So the answer to your question is that, of course, the conventions have a direct binding force on the states that have ratified. And the trend or the trajectory with international legal instruments is that states will start off with declarations and then will flesh them out into conventions that states will ratify. Does that make sense?
It does. And
yeah,
so,
Chelsea?
Example,
yes.
Just a follow-up. For example, in self-determination is in the UN Charter, but self-determination in the UN Charter is put as like in conjunction with equality and the principle of equality, the principle of which other one is it? We have it, friendliness. And so, but when you go to now the Declaration on Friendly Relations, it expounds on the idea of sovereignty, so that then it's giving even, not sovereignty, sorry, self-determination. It's giving even the instances where self-determination can be sought. And then it's giving instances, it seems to also qualify self-determination vis-a-vis territorial integrity, vis-a-vis national unity, which also the Declaration on Decolonization had done. So when you are trying to answer a question, and the question is based on self-determination, do you also, and you have been told that this state is a party to the UN, do you also bring in now the interpretation in the declaration, keeping in mind that it did come after the charter?
Yes, it does. Because the declarations, and how the declarations come up is that states are continually developing principles. So they will do declarations on specific matters. When you look at that, the Declaration on Friendly Relations, it's on a specific issue picked from the Charter, which is a general treaty. So this declaration is on a specific matter. And the future projection of law is that you would probably even have an international convention on this. So yes, it is still part of international law. It's still an international legal instrument. So it still is relevant in that sense, and you would make reference to the declarations as well.
Thank you.
Chelsea?
Yes, Doc. I don't know if it's in order for me to sort of give a response to Michael's question right now. Maybe just before I proceed, you let me know if it's okay for me to proceed.
Yes, please.
Right. I believe the topic of climate change, environmental law has been quite a popular subject of discussion these days, and it's something that I've taken a keen interest to. And I was just reading an article that was saying that in the next 50 to 100 years, there is a possibility that countries or territories such as the Maldives, Tuvalu, and I believe Nauru, and other countries that are located on islands or other island countries will be submerged as a result of the increase in the sea levels, which is caused by climate change. And I think a similar discussion was happening some time back in regards to Mombasa and how, with the increase of the number of buildings that are being built, in Mombasa, there is a likelihood that there won't be quote unquote Mombasa anymore. And just trying to answer the question, I believe that international law postulates that, territory is a necessary prerequisite for statehood. And just as you mentioned, that if a territory is reducing, it only means that that territory is reducing, and it doesn't necessarily mean that that territory would, lose its statehood, because there's the issue of the loss of the legal criteria of statehood, but then preservation of statehood through the power of, international recognition. And just by virtue of a state losing its territory, it doesn't mean that that particular territory has lost, or that particular state has lost its, statehood. Because if I remember correctly, the requirement or the territory requirement is a precondition when it comes to creating states, but not necessarily for their continued existence. And I believe this is because, international law does not necessarily hold that if a territory has been lost, then automatically the statehood has also been lost. And then there's the whole issue of, technological development, and then the functional utility of territory, basically rendering it dispensable for the continued existence of states. So just to sum it all up, a territory reducing does not mean that it has lost its statehood. Just as international law states that, international law does not mandate that loss of territory means loss of statehood. And also the territory requirement, I saw it doesn't necessarily apply to the situation of these small island states, I think Nauru, etc.